To the crisis at South African Airways, the rescue practitioners of the carrier can continue with the lockout of pilots as long as it suits them, or until the South African Airways Pilots Association agrees to their proposals. That's the considered view from Hugo Pienaar. He's a labour law expert at Cliffe Dekker Hofmeyr, the big law firm. You'll know that members of the association have been locked out by the rescue practitioners, if I'm not mistaken, since the 18th of December, and the move has been declared lawful by the Labour Court. Hugo Pienaar, good afternoon to you and a very warm welcome. You make the point in a note that this lockout is a power play. Right now, who holds the upper hand?
Thank you, Jeremy. Well, one must consider the issue in dispute, i.e. that it is the intention of SAA to cancel the collective agreements with the Pilots Association. In that comes about the lockout, which is the opposite of a strike. What happens in a lockout is that the no work, no pay principle applies. So in that sense, the employer may or often may have the better card to play, especially where no normal economic powers are at play. Because ordinarily one would think, I can't risk a long lockout because I need my employees to work, similar to a strike. And in this case, of course, it's not relevant to the extent that the employees aren't required to work in any event because of the operations not being operational. So no work, no pay, and any claims which the pilots may have during this period will also now disappear in terms of their salaries. So in that sense, it is easier for the employer to impose a lockout.
You go on to make the point, Mr. Pienaar, that the pilots then need to agree to cancel their current regulating agreement and accept new terms of employment. The way that the pilots feel at the moment, from what I understand, is they're not likely to do that. So the stalemate looks like it will continue. Does that have any broader relevance on the business practitioners' process right now?
Well, it will, in the sense that if it wants to take it out of the business rescue and start operations, then of course they won't have pilots to operate because they've locked them out. So the SAA may then have to cancel the lockout and continue with paying their salaries in terms of what they say are higher rates than the international rates. But of course, Jeremy, what is more interesting is that what may happen is that even if the pilots now exceed and say, let's do away with these regulations and let's accept the demand of SAA, then you have into play a second potential power play where the agreements are now set aside, the parties enter into wage negotiations, they deadlock, and there may be another lockout or a strike in that particular matter. Because at that stage, provided they out of business rescue, both parties, the employees need to earn and the employer needs to be operational.
So I'm wondering then whether the pilots have any further legal recourse. Could they go back to the Labour Court?
The first remedy would be to take this judgment on appeal. And of course, from the Labour Appeal Court, it can still go to the Constitutional Court. And of course, by that time, all of it may be academic. But those are the remedies. Of course, they can also say, let's sit around the table, get an expert mediator in, or another expert mediator in, and say, let's try and negotiate which agreements are critical for you and critical for us, and maybe even combine the two processes, i.e. get rid of some agreements and strike a deal on some increases where it could be prorated increases or reduced increases. That we've seen in the airlines industry.
It is becoming increasingly complicated. Thank you very much for joining us, Hugo Pienaar, a labour lawyer with the firm Cliffe Dekker Hofmeyr.